Hi, my name is Alex Dolphin. Welcome back to another episode of Ex Ante. Today we're going to talk about consumer bankruptcy generally, the different chapters that consumers have to choose from, and kind of the general process and very general process and overview over the system in the two chapters. So to begin with, there are two chapters of consumer bankruptcy. The first is Chapter 7, Liquidation. This is what most people might consider a traditional bankruptcy, where a debtor files a bankruptcy petition, all their stuff is sold, all their debts are then forgiven. So that's Chapter 7, Liquidation. Then there's a Chapter 13, Payment Plan. This Chapter 13 bankruptcy is a little bit different. Essentially, a debtor will file a petition. They will then pay their creditors, a little bit of money over a 3 to 5 year plan. And then at the end of that plan, if they've satisfied the plan and paid it in accordance with what the court ordered, then they will be granted a discharge, and whatever's remaining from their debts will be forgiven. So let's just go ahead and jump right into it. So the Chapter 7, we'll start there. So when you file a Chapter 7 petition, there's two things that automatically happen, and they happen instantaneously with the filing of the petition. The first is a good thing for the debtors. It's called the automatic stay. And so the automatic stay comes into effect, like I said, as soon as you file. And as soon as a debtor files, that means no creditors can attempt to collect on pre-petition debts. So if a debtor's incurred some debt up until the moment in time of filing the petition, and a creditor tries to contact the debtor to collect it, maybe to try and foreclose upon a home or to repossess a vehicle, well, that's a violation of the automatic stay, and that creditor is going to be in big trouble. So that is the first protection for a debtor that the bankruptcy court offers them. It's worth noting that creditors can try and move to lift the automatic stay to maybe repossess a vehicle or some property if they want to, but we won't jump too deeply into that, but something to know about. The second thing that happens as soon as a debtor files a petition is a bankruptcy estate comes into existence. And so the debtor's bankruptcy estate comes into existence, and the trustee of that estate is the bankruptcy trustee for the bankruptcy court where the debtor files the bankruptcy petition. And so what comes into that bankruptcy estate? Well, essentially all of the debtor's property is going to come in. Anything that you could think of. Pillows behind me, that painting on the wall, computers, if you have stocks, if you have cars, of course, they're in. If you have a home that's in, any other property, it's all going to be in. That is the general baseline, is if you own property and you file a bankruptcy petition, well, all of that property will become a part of that estate automatically. Now, there is one very narrow exception for asset protection trusts, which is worth noting, not worth diving into too deeply. So baseline is all of the property that you have your name on is going to become a part of that estate. So then there's what is known as an exemption. And so these exemptions basically apply. So all that property is going to come into the estate. And then once it's into the estate, you can exempt certain property from your creditors, right? And so some of that property might be a vehicle. It might be equity in a home. There's also another federal wildcard exemption, tools of the trade, a little bit of money for jewelry. So if you look through Section 522 of the Bankruptcy Code, it will show you all of the values that basically a debtor can, keep for themselves and will not be sold in a bankruptcy proceeding. So if a car is less than $4,000, well, that debtor gets to keep the car and it won't be sold, even if they own it outright, and that's the only debts. So the Bankruptcy Code allows a debtor to take a state homestead exemption, but there's some certain criteria on that. You might have to, I think you have to live there. Cut. It's also worth noting that the Bankruptcy Code allows debtors to take state exemptions for their homestead, for instance. And so some states have very lucrative homestead exemptions where you might not be forced to sell any of your homestead, right? So the federal exemption gives you $25,000 equity in a home, but Texas, Florida, those are two states that are kind of notorious for higher homestead exemptions. And so your home might not be sold at all in a bankruptcy proceeding if you take that state exemption. There are certain time limits on that state exemption. So no one can just, put all your property tied up in a Florida home and then file bankruptcy. No, it doesn't work that way. You have to own the home for a certain period of time, and it's years. So that's also worth noting. So once all of your property comes in, to the estate, all of your non-exempt property, the debtor's non-exempt property, will be sold, and it will be distributed pro rata to the creditors. Priority creditors will get money first before the rest of the creditors. Priority creditors might be your, if you haven't paid taxes, if you haven't paid alimony, child support, personal injury victims, wages. 507 shows all the priority creditors. That's not especially important for a debtor in a Chapter 7 because their stuff is going to be sold and satisfy these debts anyway. It's more something that matters for the bankruptcy court in distributing those funds, and it especially matters for creditors who are going to try and get their pound of flesh after the bankruptcy takes place. So then most debts, this is kind of the fresh start of a Chapter 7. Most debts will be forgiven. There are a few exceptions. Taxes, child support, and alimony, and student loans generally won't be discharged unless you can show a serious undue burden that these student loans are placing upon a debtor. So for the most part, all of the pre-petition debts will be discharged and you get a fresh start. Now, it's also worth noting that this doesn't apply to any debts that you incur after you file the bankruptcy. And there's also a window after you file bankruptcy where you can't file bankruptcy again. But any debts that you have incurred before filing bankruptcy, at this stage, if they weren't incurred through fraud or you didn't lie on a credit application, they're not taxes, domestic support obligations, student loans, they will be forgiven. Creditors can't attempt to collect on that. It's gone. It is out of the debtor's headspace and they are free from it. So it's also worth noting, there's an important caveat with security interests in bankruptcy. Security interests will survive a bankruptcy. So if you have a car loan on your car, it will survive the bankruptcy. You don't just get to keep the car because you filed bankruptcy without a loan. No, that will stay on there. There's a few options that debtors can take to try and maintain their secured property. The first is redemption. So redemption is special to cars. Essentially, if you have a car that is worth $6,000, but you have a note on it, your loan is $12,000. If you can come up with $6,000 cash, which is probably going to be pretty tough to do, there's some businesses that offer these types of loans, then you can go ahead and redeem that car. You pay the creditor the value of the collateral, and then you get to keep the car and you get to walk away free, and there's no more loan that survives that bankruptcy. So that's one option. It's really tough for a lot of debtors because they might not have that type of money on hand, or else they probably wouldn't be filing bankruptcy in the first place. There's also reaffirmation. This is essentially just entering into a new agreement with your creditor saying that, yes, I will continue to pay you on this car loan or this mortgage, and I'll probably pay all the deficiencies. Now, it's also worth noting that not any reaffirmation will be approved by the court. These reaffirmations do need to be approved by the court, and the debtor has to show that there's no undue burden on them in reaffirming that debt. And then finally, there's a non-statutory option, which is called the ride-through. Some debtors can take advantage of the ride-through if they are, one, current on all of their payments. So you have to be current on your payments, and you cannot be in default on the loan. And then you have to know your judge. And attorneys, if they know their judges are open to this type of an approach, the debtor will file a one-sided reaffirmation agreement with the court. The court will approve it. And essentially, you will get to keep the loan. It will survive the bankruptcy, but you will discharge any deficiencies. So say that 6 and 12 number again. You will get to continue paying the $6,000, but you won't have to pay the extra $6,000 that was deficient, that you were underwater with. That underwater amount will get discharged. So that's Chapter 7. Generally, you're going to file a petition. It's all going to come into the bankruptcy estate. All the non-exempt property will be sold and distributed pro rata to the creditors, and the security interests survive the bankruptcy. Chapter 13. This is the payment plan bankruptcy. Debtors enter into a court-sanctioned plan with their creditors, and this plan needs to satisfy 4 requirements. First, secured creditors need to be paid, and this paid subject to cram down, which we'll talk about next. Priority creditors need to be paid. So those priority creditors that we talked about earlier, taxes, domestic support obligations, those types of things all need to be paid. They don't have to pay, the debtor doesn't need to pay interest on that, but they do need to pay the present value over the life of the plan. Next, the plan needs to satisfy the best interest tests. This means that if the creditor were to file a Chapter 7 and all of their property were to be distributed to the creditors, the debtor's plan needs to at least pay that much money to the creditors in their plan. So say the debtor has $10,000 worth of property in a Chapter 7 liquidation of non-exempt property, $10,000. In a Chapter 7 liquidation, all of that would be sold to satisfy the debtor's pre-petition debts. And so in a Chapter 13 bankruptcy, the creditor will at least need to pay $10,000 over the life of the plan to satisfy the best interest test. So that's that. And then there's the disposable income test, which means that all of the debtor's disposable income needs to go towards payment of the creditors for the life of the plan. This is kind of a big one. Disposable income is calculated if you are below median income by judicial discretion. You can argue what your reasonable and necessary expenses are, and whatever is left over from your monthly income and reasonable and necessary expenses, all that needs to go. And if you're above median income, based upon the census data, then you will have a statutory predetermined budget that will be set for you, and then you'll need to pay the additional to all of the creditors over the life of the plan. So those are 4 main requirements that a Chapter 13 plan needs to comply with. So Chapter 13, there's this thing called Cram Down. Cram Down is this idea that you get to restructure your loans in a Chapter 13 bankruptcy. This is a very good thing for debtors. There are a few exceptions, so we'll just talk about those first. Primary residence, you don't get a cram down on. A car that was purchased within the last 910 days, no cram down. And anything purchased within a year, no cram down, if there's a security interest. So if you purchase something with credit, right? So like if you get a car loan, let's just talk about the car loan, that's classic. And so say you have a car loan for $10,000 on a car, and say the car is only worth $5,000. So this cram down is going to basically allow you to scrape away that $5,000 extra that you owed. You will then pay $5,000 over the life of the plan plus a prime interest rate. And so those are 2 Supreme Court cases that determine the value that debtors pay on their secured property in a cram down Chapter 13 scenario. This is very good because if a debtor has a very high interest rate, like a subprime loan, 15, 20%, well, then that's going to be restructured to a lower interest rate, right? And then also, the car, if it's completely, if the car is undersecured, so if the loan is worth $10,000 and the car is worth $5,000, so you as a debtor are underwater, well, you'll get to get rid of that $5,000 deficiency, which is another thing that's a really valuable tool in a debtor's toolkit and an asset of a Chapter 13 plan. So Chapter 13 discharge, that is granted upon payment of the plan. So you have to pay for the full life of the plan to get that discharge. And if you're below median income, you can have a 3-year plan. If you're above median income, you're generally going to need a 5-year plan unless you can pay your creditors in full over the life of the plan. But you will not get a discharge until you've paid the end of that, until you have paid that plan in full at the end of the 3 or 5 years. So what that means is if you are only able to pay the creditors a little bit of money, say, over the life of the plan, you paid all of your disposable income towards the creditors, and the creditors are still owed $90,000 at the end of your plan, and you've paid them $10,000, well, that $90,000 is going to go away. But you in good faith have to pay throughout the life of the plan. The debtor has to pay the whole plan to get that advantage of that discharge. So very generally, those are the 2 chapters. Now there's this thing called the means test. In 2005, Congress was a little bit chapped about how people were filing for Chapter 7s, and so they passed BAPCA. And what BAPCA did was it created this means test. And so this means test means that not everyone can file for a Chapter 7. There are certain limits placed on a Chapter 7 if you are a consumer. Now, businesses don't have the same limits, but consumers do. And so very roughly the test is if a debtor is beneath the median income. And so there's the website there. That's where you can find what the median income is for wherever you're at. And if the debtor is beneath that, then they bypass the means test. You don't even have to go through any of this, and they can file for a Chapter 7. That's great. Now, but if they are above the median income, it's a little bit more complicated. And you'll see those numbers there that you can just kind of run through. That's the rough framework for how the means test works. It's essentially saying that if you can repay more than $13,650 over 60 months, so over 5 years, so over $227 a month, then you might not be passing the means test. Now, it's also worth noting that there are ways to try and shift the numbers here. There's allowed expenses. So the Department of Justice has said, there's certain expenses that we're going to allow. Those might be cars, living expenses, insurance, things like that, charitable donations. And so if debtors aren't already making those payments, well, they can begin to make those payments to then shift their numbers lower and perhaps get under that $13,650 number, perhaps get into a Chapter 7. So there are ways to work with this means test, and that's what attorneys will generally help a debtor do. So, and then there's also Chapter 13 requirements, just worth talking through very briefly. Not anyone can file a Chapter 13. You do need to have regular income. Government benefits can qualify as that regular income. Also, debtors need to have less than $420,000 in unsecured debt. Unsecured debt is anything where there's not collateral. So, student loans, credit cards, personal loans, wherever there's not collateral. And then less than $1.25 million in secured debt. So if you have a massive mortgage, Chapter 13 might not be an option. But if you can't qualify for a Chapter 13 because of this, then there is a Chapter 11 option where, debtors with lots of debt and more money might be able to file a Chapter 11. It's something worth talking to an attorney about as well. So thanks so much for watching this video. I hope you enjoyed it. If you'd like to see more legal videos, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.